Good morning, everyone, and thank you very much for joining us for our webinar on disclosure. My name is Terry O'Keefe. I'm the Director of Communications and Education here, and I am joined by Farah Mohammed. Farah, why don't you tell everyone a little bit about yourself?
Hi there. My name is Farah Mohammed. I am an inspector and business standards coordinator with OMVIC. I've been working with OMVIC since the implementation of the new Motor Vehicle Dealers Act, so for approximately 5 years now. Started off as a complaints representative, and I regulate and enforce provincial advertising rules and standards as well.
And I know if you were here for our advertising webinar, you heard this story before, so I apologize if I'm repeating it, but a little dark secret of mine, I was actually a registered car salesman in another life, and to give you an idea how long ago that might have been, it was for an AMC Jeep Renault dealership. Just a little bit of housekeeping before we begin. If during the webinar you have any questions, you should all have a small box that's appeared on your screen. You can type your question into that box. We will try to address the most common questions at the end of the webinar. And if there are any questions, though, that we don't get to or that remain unanswered, we will definitely have staff here at OMVIC reach out to you and get the answer to your question. And just to give you an idea of some of the topics that we're going to be going through this morning, we're going to talk about retail disclosures, so disclosures that you're going to be making to your customers, wholesale disclosures, disclosures that you must make to fellow dealers. We're going to talk very briefly about trade-in statements, about rescission, about cancellation rights, and also about what could happen if there is non-compliance with these disclosure requirements.
All right, so again, with regards to disclosure, brief description, the Motor Vehicle Dealers Act sets out explicit requirements for dealers to disclose specific information related to a vehicle's previous use, history, and condition. Providing disclosure verbally does not meet the requirements of the Motor Vehicle Dealers Act. Dealers must exercise due diligence to ensure that all disclosures are made in writing on contracts. Pop quiz. So I'm going to ask you a couple questions, and why don't you write down what you think the 3 most common disclosures issues are within the dealer industry today.
The most common?
Most common, yes. So here is an example or just an image of daily rentals. Daily rental past use must be disclosed on a contract and signed by a consumer, if not subsequently owned by a consumer, of course.
And this is the most common disclosure problem that we see is failure to improperly disclose past use of a daily rental. And remember that this isn't just on contracts. The previous use as a daily rental also has to be disclosed in your advertising.
Yes. Number 2 is accident disclosure of an accident, $3,000 and or more.
And the 3rd most common disclosure issue?
Is out-of-province disclosure. So if the vehicle was an out-of-province vehicle, you must disclose this on the contract. If it's from a different province, you must spell out that province. If it's from the United States, you must identify that on the contract. And which state that vehicle was previously registered in. So for example, if it was a vehicle that was in the state of New Jersey around the time of Hurricane Sandy, the consumer wants to know that they're purchasing a vehicle that may have some flood damage, for example.
Well, that the possibility exists. That's actually what you're looking at. That's just some of the 250,000 vehicles that were destroyed during Superstorm Sandy. Disclosures have to be in writing, as Farah said. They cannot be done verbally, and they must be clear, comprehensible, and prominent. So as you can see here in the remarks box on this contract, vehicle is a former daily rental. That's perfectly clear. It doesn't say FDR. You might understand what that means, but to a consumer that would mean absolutely nothing. So this is clear, comprehensible, and prominent. And this one always makes me laugh. This is actually a stamp that one dealer had created and was using on their bills of sale. And as you can see, it says, customer has received a car proof report and is aware of all vehicle history in previous province, country of origin. This is clearly not clear, comprehensible, and prominent. It's really important that you spell it out. It's a great idea to give your customers a copy of a vehicle history report. We're not saying don't do that, but that in and of itself is not disclosure. It doesn't mean that they read it. It doesn't mean that they understood it. So disclosures must be in writing, clear, comprehensible, and prominent on the bill of sale. And that would also, when it talks about province, country of origin, we often we'll see on a contract QC. That was a dealer's attempt to say that the vehicle came from Quebec, but to some consumers it meant quality control. It doesn't mean anything. It's got to be spelled out clearly and prominently on the bill of sale.
Exactly. Normally when I'm discussing this with other dealers, consider it being a newcomer to Canada that isn't well acquainted with the various different provinces. They might not know what the abbreviation of QC means, so try to spell out if the province, the state, wherever that vehicle came from. Don't use abbreviations. As a best practice, spell it out. Prior use disclosure. Again, this is very, very important. If the vehicle was previously used as a taxi or limo, used as a police cruiser, emergency service vehicle, or daily rental, unless subsequently owned by someone other than a dealer, this must be disclosed in writing on the contract. With regards to collisions and or incidences of damage over $3,000, this too must be disclosed in the contract and signed by the consumer. We understand that sometimes car proof reports are given to the consumer. It's explained to the consumer understands. You're verbally disclosing this information to the consumer. However, that will not suffice. It must be made in writing on the contract.
And the Act also requires that if you know the amount of damage, that you also disclose that figure. So if the car proof report said that the vehicle had sustained accident repairs of $6,752, that information would also have to be disclosed on the bill of sale. And it's really important that dealers not rely on reports that don't provide that kind of information. Obviously, OMVIC's not going to recommend a report, but we do encourage dealers to educate themselves about the strengths and weaknesses of all reports. None are perfect, and make sure that you do know, though, the strengths and weaknesses and use the report or reports that will best allow you to provide disclosure. Unfortunately, we have seen instances, and it doesn't happen often, but we have seen instances where a dealer has written on the bill of sale, no accidents as per Carfax. Well, that's simply not good enough. There's more due diligence that has to be done other than simply referring to a history report. Obviously, you have to conduct a thorough physical examination of that vehicle as well. And in that particular instance where the dealer had written on the bill of sale, no accidents as per Carfax, they actually had a different history report that showed there was a claim, and they chose not to disclose it by relying on the statement that they made. And this is obviously a contravention of the Act.
Disclosure is also required if structural damage or repairs or alterations have been done to the vehicle. If fire damage has been sustained, flood damage, liquid penetration at least to interior floodboards, the vehicle, or if the vehicle has two or more adjacent panels that are not bumper-to-bumper panels that have been replaced, all of these things must be disclosed in writing on the bill of sale.
And of course, you have to disclose if the vehicle has ever been branded. So if it's been, if it has been written off and now it's either salvaged or rebuilt or possibly irreparable, of course that vehicle couldn't go back on the road, that has to be disclosed in writing. Now, something that sometimes dealers might misunderstand is that they also have to disclose if the vehicle's been declared a total loss. So it might have been declared a total loss but not branded. That can happen. It's possible. So if that did happen, you would have to declare the vehicle at total loss or disclose the total loss, even if it wasn't branded. You also have to disclose if the vehicle's anti-lock brakes aren't operating or the airbags are missing or don't function. Because even though a vehicle will pass a safety, if the ABS isn't working or the airbags aren't there, it'll still pass a safety, but you must make that disclosure in writing on the bill of sale. And this one sometimes surprises some dealers. You have to disclose if repairs are required to the following major components: the engine, transmission, powertrain, subframe, computer, electrical system, fuel system, air conditioning. And I kind of take a gasp there because dealers are sometimes surprised. Yes, if the air conditioning is not functioning properly, you must disclose it on the bill of sale. Now, sometimes we'll get asked, by a dealer, they'll ask or pose the question that I sold the car in February, it didn't get warm, and the consumer, didn't turn the AC on until the May 24th weekend, and it's blowing warm air. Am I going to be responsible for that? Well, the answer would be, when you sold the car in February, did you check to see if the air conditioning was working properly? Did you have your mechanic, when they were conducting the safety inspection, check these systems? If you can demonstrate that the vehicle was working properly and the air conditioning didn't require repair at that time, and you've got documentation to show it, and obviously there's no warranty on the car, then you've protected yourself. But if you can't demonstrate that you checked, when that consumer comes back in May and says, I just tried the AC for the first time and there's a problem, you may well, be on the hook for trying to rectify this problem, because the Act requires you to disclose if the air conditioning requires repair at the time of sale.
If the vehicle was ever registered outside of the province of Ontario within the last 7 years, and where, this must be disclosed on the bill of sale. So going back to one of the most common areas of non-disclosures that we've seen, out of province is very common. So be sure to do your due diligence, practice due diligence, and find out if the vehicle was registered outside of the province of Ontario within the last 7 years, and be sure to disclose this on the contract. Also, if the vehicle was ever stolen and or recovered, this too must be identified on the bill of sale. With regards to distance traveled, odometers and contracts must accurately reflect the true distance a vehicle has traveled. However, when mileage is unknown, if possible, provide the last reported mileage on a given date, as well as a statement that the actual number of kilometers is higher. If past mileage or the date is not known, declare the total distance traveled has been driven is unknown and may be substantially higher than the reading on the odometer. The statement must be CCP. TKU is not acceptable. No abbreviations. This exact statement must be on the contract if it falls under this category.
Yeah, and I think FAR raises an important point. The old commonly used acronyms and terms, true mileage unknown, true kilometers are unknown, are simply not allowed anymore. If you do have a vehicle with an odometer that's rolled back, you must use one of these two disclosures, and you must use the exact wording. And don't worry if you can, if you think you might have a vehicle like that and you're looking for this wording, it's all available on our website, or of course you can contact us here at OMVIC. We'd be pleased to help. New vehicles. If a vehicle's not in stock, you're going to have to locate it and bring it in. When the consumer signs that contract, the contract should show a maximum distance, or there should be a statement that there is no maximum. The consumer will accept it with whatever it shows up with. And if you go that route, you'd have to have the purchaser initial that statement. So if you're a dealer here in Toronto and that car is going to be brought down from Sudbury, that's where you've located it, you're probably going to have to contact the dealer in Sudbury, figure out how many kilometers are on it on his or her lot, how far is the trip to bring it down here if it's going to be driven and not trucked down, and put that distance. That's that maximum distance we're referring to. So the contract has to have one of those for a new vehicle that's going to be located and brought in, a maximum distance or a statement that there is no maximum, and that statement has to be initialed. As well, the contract must include the vehicle's model year, make, model, and trim level. I know that that seems very, very straightforward, but when we get to talk about rescission, you'll see why this is really, really important. Some other disclosures that are required. If the vehicle has been modified, if the vehicle is materially different from the original or advertised production specifications, if the manufacturer's warranty has been canceled, or if the vehicle's odometer is broken or faulty, has been replaced or rolled back, or is in miles.
Buyer-specific disclosures. Often you have consumers coming into dealerships asking, has this vehicle ever been smoked in? Or will this vehicle fit my car seats for my twins? If a buyer makes a specific request for information about a vehicle, disclose that information and include it on the contract.
And this is really important, not only, because the consumer is telling you that this is material to them, this is a material fact to them, this is important to them, but sometimes you might not be able to answer the question, so this is also a way for the dealer to protect him or herself. If the consumer came to you and said, has this vehicle ever been used to tow? And you're able to tell them, there's never been a trailer hitch installed on this vehicle, so no, it's never been used to tow. Write that on the contract. But what if there's already a trailer hitch on the vehicle? Maybe it came from the factory with that. There's no way for you to know if this vehicle was used to tow or not. So write on the contract, consumer requested to know if vehicle used to tow, unknown. And this way, if there's a problem down the road, yes, they did ask that question, you're acknowledging it, but you're also making it clear that you weren't able to tell them and they've chosen to go ahead with the transaction based on that information.
Buyer-specific disclosures are also material facts. So you must disclose any fact about a vehicle's history, performance, or quality that might be expected to influence a reasonable consumer's decision to purchase that vehicle and determine a fair price. So, for example, you see that warranty sign that we have up here on the image. If a dealership buys new vehicles, for example, and those vehicles are now registered, it activates the manufacturer's warranty. That is a material fact to many consumers. So you must disclose this on the contract. Be aware that there are material facts that might not fall under the requirements of the Motor Vehicle Dealers Act to be disclosed. Section 4225 specifically states that any material fact that could subsequently alter a consumer's decision in purchasing a vehicle must be disclosed on the contract. So even if it was an accident that was $1,500, if the consumer asks, has this vehicle ever been in an accident, write it on the bill of sale. Yes, if you're providing them with a car proof and it was $1,500, write the dollar amount on the bill of sale because the consumer asked about it.
But by them asking, has this vehicle ever been in an accident, even if it's less than $3,000, they are telling you this is material to them. So it's important that you make sure you make that disclosure. And you can see the picture of the snowplow. The snowplow is not one of the named disclosures. It's not taxi, limo, police, emergency service vehicle, snowplow. That's not how the Act reads. But I don't think very many of us would argue that snowplows get driven really, really hard, especially yesterday and today. And so, I would want to know before I bought a pickup truck if it had ever been used to plow. That would be material to me, and it would probably be material to most of us. You'd probably want to know that too if you were taking one in on trade. So this is some ideas of material facts. These are things that aren't specifically named in the Act, but that might influence a reasonable consumer's decision to either purchase that vehicle or to determine a fair price for it.
So going back to the question, can it be material if damage is less than $3,000? Yes.
Absolutely. For me personally, if it was a brand new vehicle, and let's say that it had been damaged in transit, and the repairs were $2,900. It falls under, it's less than the $3,000. But it's a brand new vehicle. It's got, a number of panels that have been repainted, not at the factory. I would want to know that as a purchaser. And I think I'm a fairly reasonable average consumer that way. I think most of us would want to know that. Another pop quiz for you. So we've gone through all the required disclosures. So the question is, are they required if you're selling the vehicle as is with the as is statement signed? What do you think? The answer is yes. Even if you're selling the vehicle as is, all disclosures are still required to be made in writing on the bill of sale. Farr, do you want to weigh in here?
That's correct. I mean, if you've got an inspector coming in, and we've got a lot of dealers confused about this when we're going in there in person, and they're like, but Farr, we sold this vehicle as is. We don't have to provide these disclosures on the contract, and we gave them a car proof. That won't suffice. Again, verbal disclosures will not suffice. You must provide all of the pertinent information on the contract with regards to the as-is vehicles as well. Rescission. Rescind, to cancel, repeal, revoke. While rescission is not automatically granted for every breach of the disclosure requirements, the Motor Vehicle Dealers Act spells out specific circumstances in which a consumer may cancel a contract and receive back all monies paid to the dealer. This remedy is available to any consumer who is not a registered dealer, and if you want a reference point, Section 50 of our regulations clearly identifies the areas to which a consumer falls under their rescission rights. So what are the 6 deadly sins to get rescission? The Motor Vehicle Dealers Act allows a consumer to cancel a contract or rescind a contract if a dealer and contract fails to disclose or fails to disclose in a timely way the following: previous use, if the vehicle was a previous taxi or limo, if the vehicle was a previous emergency service vehicle, past use as a daily rental, make, model, and year of the vehicle, that the vehicle was branded, salvage, rebuilt, irreparable, and how it was last classified, and the actual distance the vehicle has traveled. When that can't be determined, a dealer must make the appropriate disclosure statement, which we mentioned in previous slides. We did get a question from one of our listeners asking, does it need to be disclosed on a retail bill of sale if the vehicle was owned by another consumer in between? This is with reference to a daily rental. The Act specifically states if not subsequently owned by a consumer. However, if you believe that the purchaser would have wanted to know that this vehicle was a previous daily rental and you believe that it is a material fact for the purchaser, disclose it on the contract.
Under the Motor Vehicle Dealers Act, failure to make any of those 6 disclosures, even if the dealer is unaware, triggers the purchaser's right to rescission within 90 days of delivery. So you bought that vehicle in good faith. You did not know the odometer was rolled back. It doesn't matter. The customer is still entitled to rescission. It's worth noting, too, that rescission also cancels any other agreements under the contract. So if they also purchased an extended warranty, that gets unwound. When the customer returns the vehicle, if the deal is being rescinded under this section of the Act for these non-disclosures, the dealer cannot charge for usage of the vehicle. Now, the customer, obviously, it's expected that they're going to return the vehicle to you in good condition, that they haven't, smashed it up, but you cannot charge for usage. And also, it's worth noting that consumers, if someone meets the definition of a consumer, they may have up to 1 year to request rescission if a dealer commits an unfair business practice, and this could also include things like failing to disclose a rolled back odometer.
Indeed.
What about the trade-in? So let's say that you actually have a customer, they've purchased a vehicle from you, and it turned out it had a rollback odometer. You didn't know. But they've learned and they've come back now and they want to rescind the deal. But the trade-in is gone. You've sold it. That's not a problem. You'll simply return to them the stated value of the trade-in on the contract. I can probably hear some gears turning right now. So it's important, though, that you recognize that if you have inflated the selling price, let's say by $3,000, as it says in the example here, and inflated the trade-in credit by, say, $3,000 because this customer's got negative equity in their trade-in, you will be responsible for returning the inflated trade-in dollar amount. If the trade-in can't be returned, the expectation is that you will return the stated trade-in value on the contract. So this is why it's really important that you protect yourself and demonstrate negative equity clearly on contracts. Try not to hide it the way that it's being done in the example that we've given.
Yeah, often we get questions from dealers, where do we disclose this on the contract? How are we supposed to allow the consumers to be aware of it and be confident that the consumer is aware of the negative equity? In the comment section, just make a note of it, what the negative equity is of the vehicle, and have the consumer sign it. It's for your own protection as well as the consumers.
So we've been talking about the disclosure that you have to provide to your customers, but disclosure isn't just for consumers. Because if you're purchasing a vehicle from another dealer, wholesale, or from an auction, how can you be expected to make all these disclosures to your customer if the dealer who has sold the vehicle to you didn't make them to you? And OMVIC's Code of Ethics regulations has sweeping requirements that outline all the information dealers have to provide one another when trading in vehicles. And these requirements, but sometimes when people hear Code of Ethics, they think, well, lots of industries have Code of Ethics, and their agreements will try and operate this way. They're pledges and promises. The Code of Ethics for registered dealers are not best practices or guidelines. They're the law. They're written right into our regulations, and they're enforceable.
Wholesale contracts. So going back to the Code of Ethics, Section 5 of the Code of Ethics goes through all of the requirements that a dealer must make to another dealer or on a wholesale bill of sale. All of the same information that is required on contracts with consumer, with the exception of the needed repairs to major components, must be disclosed when you're selling to another dealer, selling through an auction. This, just as with consumers, dealers too, their trades must disclose all material facts that might influence a reasonable purchaser's decision to buy or determine a fair value.
So it's really important, and I want to stress this, that when you sell a vehicle to another dealer, you have to make the exact same disclosures you would to any customer with the exception of needed repairs.
Yes.
Unless, of course, those needed repairs would be a material fact. Farah and I often give the webinar that you're seeing today as a seminar right in dealerships. They've requested that we come in. And this is one area where we see the processes within the dealership may sometimes break down. We've seen dealers that they collect all the information from people trading in cars. They've collected the information as they should. But unfortunately, the person at the dealership responsible for wholesaling the vehicles is unaware of it. They don't actually get the deal jacket or the file for that vehicle, so that when they're wholesaling the car, they don't know about the disclosures that have been made, and therefore they're not being made. And a number of dealerships that we've presented to have recognized this as a problem within their own store and have taken steps to correct it to make sure that they're providing full disclosure even when selling wholesale. And obviously, wholesale disclosure is going to be required for any vehicle that you send to the auction to be sold. Make sure that the auction is made aware of any required disclosures. And as we just talked very briefly about, when dealers take a vehicle in on trade, the Act requires, it's actually a legal requirement for dealers to sit down with the customer trading that vehicle in and go through a disclosure form and ask the person trading the vehicle in those questions. Has this vehicle been in a fire? Has it been in a flood? Probably not. You might know those things, but accident, maybe out of province, maybe. This is a way for you to start collecting the information, because again, if you don't ask for it, if you don't collect it, it's going to be impossible for you to provide it to the person that you sell the vehicle to, whether it's another dealer or a customer.
And be sure that if you are taking a vehicle in on trade and you're asking these questions to the seller, be sure that when they're providing you with information, you still exercise your due diligence to find out the history of that vehicle. Okay, so pull your history reports. If you feel as though there's something wrong with the vehicle after your inspection that wasn't disclosed to you at the time of purchase, make sure that you pull a history report to find out that information.
And that's a really important point, Farah, because I've actually spoken with dealers who have told me that they rely entirely upon the trade-in disclosure statement that they've got from the customer trading the car in. And that's probably not a best practice that we would want anyone to develop, because sometimes that customer who's trading that vehicle in may have forgotten information about it. Sometimes they might not be the original owner. They're unaware that this vehicle was involved in a collision 2 owners before them. So as Farah said, maintaining due diligence, not simply relying on the trade-in disclosure statement that you've got from your customer, and doing that inspection and history reports is very important.
If you're selling a vehicle and you do provide a history report to a consumer and it doesn't adequately provide the appropriate disclosures, and the consumer is able to find out that information, we do take the position that if a consumer can find this information out, the dealer should have been able to find the information out as well. So what happens if a dealer is found to be not in compliance with these requirements? In some cases, a caution letter could be issued. A notice of complaint, which triggers the disciplinary process and or hearing, could be triggered. You could be faced with provincial offenses charges, or a proposal to revoke the dealer's and or salesperson's license. So just be aware that if you're not in compliance, not limited to, you could fall under one of these categories here, and that's not something that you want to be a part of. So what are the 2 most common reasons for a dealer, for example, going through the discipline process? As a trend, what we're seeing is non-compliance in dealer advertising and non-disclosures on contracts, whether it be retail and or wholesale.
And something interesting about the discipline process, if there's actually a hearing, if it gets to that point, it's not a judge who sits there. It's actually a panel of your peers. It'll be a panel of 3 people, and 2 of them will be dealers. And as Farah had said, non-disclosure on contracts is one of the most common reasons why a dealer might find themselves before a discipline panel. And very often they will say, but the consumer knew that it was a daily rental. The consumer knew about the accident history. And the Act and the discipline panels themselves have been very clear. But simply knowing because they were told verbally is still a violation of the Act. The Act requires those disclosures to be in writing on the bill of sale, and that's and they're very, very consistent in interpreting it that way.
So what are some of the consequences, the penalties and or fines? If you're in the disciplinary process, you receive a notice of complaint and it triggers a discipline hearing, you could be charged up to $25,000 per party named on that notice of complaint. So it would be the entity and all registrants involved could be listed on the notice of complaint. So be aware that if going through the disciplinary process, it's not limited to just $25,000 for one notice of complaint. It's $25,000 per party named. If you're faced with charges, provincial offenses charges, an individual's fine can be up to $50,000 and or 2 years less a day of imprisonment. A dealership can be fined up to $250,000.
And something else that the Motor Vehicle Dealers Act requires is that OMVIC make available all this information, proposals to revoke or suspend registration, charges, convictions, and discipline committee orders. So if a dealer does find themselves going through the discipline process and is found to have breached the code of ethics, OMVIC must make that information public. And that information is, you can see on the right side, that's just some of the most recent ones from 2014. And I want to stress, this is not OMVIC in any way trying to embarrass a dealer. We must make this information public.
We're obligated. Yeah, we are obligated to make this information public. I mean, I myself, I do deal with a lot of notices of complaints, Terry, and often I do get dealers expressing to me that they don't want their names published. But unfortunately, if not in compliance with, in this case, disclosure requirements, we must, it's our obligation to make this information public, and that's not negotiable.
Yeah, we are bound by the Act to also make disclosures. So we just want to go through a quick summary if we can. The Motor Vehicle Dealers Act sets out specific details that must be disclosed, and they have to be disclosed in writing. And as it says, just as you would want those facts when you're purchasing that vehicle or accepting it in trade, the Act requires that dealers provide that information to their customers. Disclosures must be clearly, comprehensibly, and prominently written on the contract. They have to be provided in a timely manner. In other words, you can't make disclosures after someone has signed that contract. And failure to make those 6 disclosures that Farah talked about automatically triggers any customer's right to cancel that contract within 90 days of delivery.
So failing to make the appropriate disclosures may result in cancellation of the contract and or administrative action. So that's the warning letter, correspondence between OMVIC, your notice of complaint, proposal to revoke. Trade-ins, it's the legal requirement to have a completed trade-in disclosure statement. I know that there are some companies that have specific trade-in disclosure statements and trade-in disclosure checklists as well, so you might want to do some research to obtain some of those. A little bit about rescission again, just to recap. The Motor Vehicle Dealers Act gives consumers the legal right to cancel a contract should the dealer fail to make specific disclosures. Customers are entitled to rescission and have up to 90 days after the purchase, and they can cancel any other agreements under the contract, and consumers may have further rescission rights under the Consumer Protections Act for a period of up to 12 months. With regards to wholesale, please be reminded that dealer-to-dealer disclosures is a legal requirement as well, as per Section 5 of the Code of Ethics Regulations. To help ensure that dealers provide full disclosures to their retail consumers, it's important that they make proper disclosures in wholesale transactions. This way, dealers and ultimately their customers will be able to make fair and informed decisions.
And I know we've gone through a lot of information, but I want you to know that we're here to help, and we've got resources available on our website that are also there to assist you. And as you can see from the slide in front of you, this is, if you go to our website, the tab you see that is highlighted in yellow there, the MVDA requirements, if you just click on that, you'll get that drop-down menu, and there's disclosure. And this is all the information that is actually contained in the certification course textbook about required disclosures, about the $3,000, and there's also just a little bit further down another tab there for rescission. So that information is all available on our website and very easy to find. And I also want you to know that if you have any questions, and questions that we don't get answered for you today, or some that crop up in the future, we're here to help. You can contact our complaints and inquiries team. Sometimes dealers might think, oh, that's just there for consumers. It's not. The complaints and inquiries team is there to assist consumers or dealers, whether you're having a dispute with another dealership or you simply have a question. And you can contact them at that phone number or at that email address. And I also want you to know that we are recording the webinar right now, and it will be available probably next week on our website. You'll be able to review all of this. So that's the end of the webinar. Farah's been sitting here beside me for the last minute or so, going over some of the more common questions that have come in during the webinar. So I'm going to turn it over to you to read it out and see if we can get the answers for them.
Yeah, we have some questions regarding Section 50 and the rescissions. One of the most common questions is, how many days does a consumer have to cancel a contract if it falls under the Section 50 rescission requirements? And that is 90 days under the Motor Vehicle Dealers Act.
From the date of delivery.
Exactly.
Not from the date of signing the contract, from the date of delivery.
Exactly. And also be aware that the Consumer Protections Act also states for a period of up to 12 months. So it's not only the Motor Vehicle Dealers Act that requires you to make these disclosures, it's the Consumer Protections Act as well. We've also got some questions with regards to if some or of these disclosures are on the used vehicle history disclosure form, are they still required to be on the contract? Yes. You must have all of this information, all of the required information on the contract. Having another document, a car proof with a consumer signature on it, that will not suffice. Providing them with your wholesale bill of sale, for example, that will not suffice. You need to have all of the required information written on the bill of sale.
And that's not to say that providing your customer with a copy of a vehicle history report isn't a good idea. It's a great idea. But that in and of itself is not considered making the required disclosure. It still needs to be written on the bill of sale.
Exactly. And going back to daily rental disclosures, we got a question asking, is writing daily rental on the windshield required, or can we just let them know before a test drive? If an advertisement is published, and that does include a windshield, you must specifically write if the vehicle was a previous daily rental. So if you have it in the advertisement, it must too be disclosed on the contract and acknowledged by the consumer.
And we've got a few other questions that have come in. One asked, does the consumer not have to get a car proof? No. There is no requirement under the Motor Vehicle Dealers Act for a dealer to provide a vehicle history report. Having said that, many dealers do as a best practice, and we would, I think that's a great idea. If I was purchasing a vehicle, I would love to see the car proof report or another vehicle history report that came along with that. It would certainly help build trust in my dealings, but there's no requirement under the Act for it.
We've got another question. Are you obligated to disclose damage of less than $500? Again, if you believe that this is material to the purchaser, that this would alter the consumer's decision to purchase the vehicle, disclose it on the contract. If it's a $200 claim on a car proof or Carfax or, auto check, you must disclose it on the contract if you feel like it is important information to the consumer.
Or if they have specifically asked, has this vehicle been involved in a collision? And I also think, and this is just my own personal opinion, but if you disclosed a $500 collision, I don't think that it's going to affect many consumers' decisions to purchase that vehicle, and they're actually going to know that you're being completely transparent and upfront with them and honest with them, and I think that that could only be good for that particular dealer.
Yeah. We've got an advertising question, it looks like here. Are demo vehicles advertised on the website? Do you have to advertise them as new or used? And this is a hot topic in our advertising seminar, Terry, which we provided about 2 weeks ago, I believe. Demo vehicles must be identified as used, not only on the advertisement, but on the contract as well.
And this question also has come up many times, and the question is, the damage to the vehicle was $5,000, but it only cost $2,000 to fix. What amount to disclose? My suggestion would be to disclose both. Obviously, you want to be fully transparent. If a dealership is able to conduct repairs to a vehicle for $2,000 when the repair estimate was $5,000 because they've got in-house labor rates or they're using parts from a wrecker, that kind of thing, as the purchaser, that would be material to me. It might fall under the $3,000 because it was repaired for $2,000, but the fact that it had a $5,000 or a $6,000 repair estimate, I think would be material to most consumers. And as a best practice, I think that always trying to provide that kind of transparency is the route to go.
Yeah, often I see on some history reports it would just say police report with no dollar amount. But some consumers do believe that this is material. They want to know why there's a police report attached to the motor vehicle that they're driving. So be sure that if you think that it's material, again, disclose it on the contract.
Another question, does Ontario have a lemon law? The simple answer is no, we don't, but many jurisdictions in the United States do. So if you actually have a vehicle that has been brought into Canada from the U.S., and while it was in the United States, it was actually declared a lemon, I think that's something you're going to want to disclose. That would certainly be a material fact to most people. And that's all the questions that we have right now. If you have sent in other questions, or if you have others, we will definitely make sure that they are answered via email or return phone call. And I want to thank you all very much for joining us.
Thank you. And if you have any questions, again, you can contact our Complaints and Inquiries Department. They are well equipped to answer your questions. If you've got the contact information of the inspector in your area, you can contact them as well. Contact our 800 number, extension 5105, and our Complaints and Inquiries team would be happy to answer any of your questions.
And we'll leave that slide up for another 60 seconds so that you can write that information down. And again, on behalf of Farah and myself, thank you very much for joining us.
Thank you.